Okay, let's unpack this. Have you ever felt like you couldn't quite speak your mind? Maybe because of, fear of retaliation, especially from someone with more power, or frankly, just deeper pockets. Imagine wanting to raise a concern about something happening in your neighborhood, maybe a new development, or even just sharing an opinion online, but you hesitate. You worry about being dragged into some costly, draining legal fight.
Yeah.
That that chilling feeling, that kind of self-censorship, that's precisely the human experience we're diving into today.
It really is. And what's fascinating here, or maybe disturbing, is how that very fear is systematically weaponized through something called a SLAPP suit. That stands for Strategic Lawsuit Against Public Participation.
SLAPP suit. Okay.
Yeah, it's a legal maneuver, and it's profoundly intentionally designed. It's not always about winning in court on the merits. It's about silencing dissent. It leverages the immense financial and, honestly, the emotional burden of litigation just to make people back down. Doesn't matter if what they said was true or had merit.
So it turns the legal system into a weapon.
Exactly.
Right.
From a forum for justice into a tool for intimidation.
Okay, so today we're taking a deep dive into Maryland's ongoing battle against these kinds of lawsuits. We're going to explore why Maryland's current law, even though they were kind of early to the game, is now considered, well, remarkably weak. We'll look at who it disproportionately affects, often the most vulnerable citizens and just regular community members. And we'll examine how a recent, pretty high-profile case has breathed urgent new life into efforts to finally strengthen it. Our mission here is to really understand this intricate dance between our fundamental right to free speech and the insidious threat of legal intimidation. It was finally being done to level the playing field for everyday citizens, making sure that simply participating in public life doesn't come with this unbearable personal cost. So just to lay the groundwork, what exactly is this SLAPP suit? Break it down for us.
Right. So at its core, it's often a baseless lawsuit. Or maybe it has a tiny grain of something, but it's essentially meritless. But like I said, that's almost beside the point. Its real purpose, its design, is to drain the defendant's resources, money, time, energy, and critically, to silence their public participation or criticism.
So it's like legal bullying, basically.
That's a perfect way to put it. Legal bullying. The goal isn't necessarily a legal victory. It's imposing such a heavy financial and psychological burden that the target just gives up. They're forced to abandon their speech or their advocacy. It's really an abusive use of the legal system. It turns a legitimate tool for seeking justice into a weapon for suppression. The success of a SLAPP suit isn't measured in courtroom wins, but in the silence it creates.
That makes sense. And these anti-SLAPP laws are supposed to stop that.
Exactly. If we connect this to the bigger picture, anti-SLAPP laws are designed as a crucial shield. They're a vital First Amendment measure. They're intended to protect the fundamental right to healthy debate, robust public discourse, and, importantly, the essential ability to petition the government for redress of grievances.
Petition the government. What does that mean in simple terms?
It means having the fundamental right to bring your concerns directly to your local government or your elected officials, to complain about something you think is wrong, seek a solution, all without that chilling fear of legal backlash. These laws aim to prevent the wealthy and powerful, those with deep pockets and significant influence, from weaponizing the courts, from turning what should be a forum for justice into a costly cudgel to silence critics and deter legitimate civic engagement.
Right, because without strong anti-SLAPP protections.
The powerful can effectively buy silence. It undermines the very principles of free speech and open governance that underpin a healthy democracy. Many states have recognized this. They understand that without such protections, really, only the loudest and richest voices can afford to speak.
And here's where it gets particularly interesting, maybe even a bit strange. Maryland actually passed its original anti-SLAPP legislation way back in 2004.
Yeah, they were ahead of their time, in a way.
Right. They saw this emerging threat and tried to address it. But since then, while other states have, diligently strengthened their provisions, learned from experience, Maryland has unfortunately fallen significantly behind. In fact, this watchdog group, the Public Participation Project, they meticulously grade states on how strong their anti-SLAPP laws are. They now give Maryland's law a dismal D grade.
A D. That's
Yeah.
pretty bad.
It is. So it raises this pressing question. How did a state that was once a leader in protecting free speech slip so far? How did it leave its citizens so vulnerable to these aggressive legal tactics? What crucial element did Maryland miss in its initial legislation, and why has it persisted for, almost 2 decades now?
Well, that leads right into the question of who truly bears the brunt of a weak anti-SLAPP law. It's easy to think, oh, it's just corporations suing each other or politicians.
Right, big players against big players.
But the reality is far more sobering, and frankly, it's often heartbreaking. It's often the most vulnerable among us who are left exposed, precisely because they lack the resources to fight back. Katie O'Malley, she's the executive director of the Women's Law Center of Maryland. She highlighted this devastating reality during recent testimony. She explained that their clients, mostly in the protective order cases and in the Title IX investigations, are particularly at risk.
Protective order cases, Title IX, can you unpack that a bit?
Absolutely. Imagine, just for a moment, the immense courage it takes for a victim of intimate partner violence to finally seek a protective order, right? To break free from an abusive situation. Or for a survivor of sexual assault to come forward with their story in a Title IX investigation, usually on a campus or in an educational setting.
Incredibly difficult situations already.
Exactly. They are already navigating immense emotional trauma, practical difficulties. Now layer on top of that the chilling threat of a costly defamation lawsuit, a SLAPP suit filed in retaliation, just for trying to seek safety or justice. This tactic can completely undermine their efforts. It forces them to choose between their safety and potential financial ruin. It's a terrifying prospect.
So it forces victims back into silence.
It can, yes. It allows abusers to continue their harmful behavior unimpeded. And the current Maryland law, by failing to provide an easy path to dismiss these retaliatory suits, it just exacerbates that power imbalance and traps victims in a cycle of fear.
And it's not just those incredibly sensitive cases, right? You mentioned regular citizens too.
Correct. Individuals who comment about matters of significant public importance, maybe it's expressing an opinion on a local zoning change, questioning a public official's decision, or even engaging in civic action, like signing a referendum petition.
Which is just trying to get something on the ballot for people to vote on. Right.
Exactly. A fundamental act of democratic participation. These actions, which are cornerstones of a healthy, active democracy, can trigger what O'Malley and others describe as malicious, costly lawsuits, designed solely to intimidate them into silence and deter further participation.
So the profound insight here isn't just that these lawsuits are difficult. It's that the very people who need protection the most are often left exposed. They're forced to back down just because of the sheer cost and anxiety of maybe facing litigation, even if they're completely in the right.
Precisely. The threat of crushing attorney's fees, the significant time commitment for court appearances, depositions, all that, and the immense emotional stress of being sued by some powerful entity. It's often enough. People withdraw statements, remove critiques online, or just stop engaging altogether.
And that creates a chilling effect.
A significant chilling effect, not just for the specific individuals targeted, but for anyone who witnesses it. It leads to a quieter, less vibrant public square where, only the loudest and richest voices feel safe enough to speak freely. It stifles local journalism, community activism, the very watchdogs that hold power accountable.
Now, this chilling effect we've discussed, it isn't just theoretical, is it? Sometimes it takes a really vivid, real-world example to galvanize action, and Maryland recently had one that dramatically amplified the call for reform. Let's delve into this situation that put Maryland's anti-SLAPP law squarely in the spotlight and gave a significant urgent boost to these long-stalled reform efforts. This isn't just theory, it's a stark example of how these tactics play out and how they can even touch people in positions of power, bringing this abstract concept of a SLAPP suit into sharp personal focus.
Right. This particular twist involves a situation that unfolded in Fells Point. That's a historic neighborhood in Baltimore, right? Known for its waterfront nightlife.
Yeah, charming place, but can get noisy.
Exactly. And residents there signed a petition to the city liquor board about a new bar proposed by the Atlas Restaurant Group. Now, Atlas is a major player in Baltimore's dining scene, but they were also known, apparently, for frequent noise complaints from their other places. And this specific proposal was for a significantly large outdoor seating area right next to residential backyards, promising late-night revelry.
Okay, I can see why residents would be concerned.
Absolutely. Deeply concerned about potential noise, disruption, decline in quality of life. Their petition was just a simple, legitimate act of civic engagement, exercising their right to voice concerns about something directly impacting their homes.
What happened next, though, really brings the core problem into sharp relief, doesn't it? Senator Shelley Heddleman, who's sponsoring the bill to strengthen the anti-SLAPP law, she held up a letter.
She did. During a recent committee hearing in Annapolis, she held up a copy of a threatening letter. This letter was sent by an attorney hired by Atlas Restaurant Group directly to the people who signed the petition.
Directly to the residents.
Yes. And the message was Chillingly clear. Stark. It basically said, shut down your opposition or we're going to sue you.
Wow. Not subtle.
Not subtle at all. A direct, explicit threat of legal action against citizens for simply engaging in the democratic process of petitioning their local government.
I can only imagine the sheer dread, the confusion of opening a letter like that, especially if you're just trying to protect your home. What's the immediate psychological impact of a targeted legal threat like that?
Oh, it's designed to be devastating. The immediate impact is often profound shock, then intense anxiety, a pervasive sense of vulnerability. It's not just a legal document, it's a weaponized piece of paper, and it works by making you second-guess your most basic civic impulses. Many people instantly wonder, was my voice worth this? They realize, often for the first time, the massive power imbalance. The prospect of fighting a wealthy corporation's legal team is utterly terrifying. It's an instant chilling effect, far more potent, perhaps, than any actual lawsuit might be.
And this story gets even more interesting because of who received one of these letters.
That's right. Among the households receiving this chilling letter was that of Maryland Comptroller Brooke Lierman, specifically her husband, Aben Hansel. Now, Senator Hettleman didn't explicitly name Lierman during her public testimony, but it was widely known within Annapolis political circles that the comptroller's household was directly impacted.
So a top state official's family was targeted.
Correct. And this personal connection, impacting a high-profile public official, brought an undeniable level of visibility and urgency to a legislative effort that, historically, has often struggled to gain consistent traction in previous years. Her subsequent involvement in advocating for the bill, doing so in her personal capacity, is considered really helpful by advocates like Howard County Attorney Tom Cole. It starkly demonstrated that even those with significant public standing aren't immune. It signaled that this isn't just some abstract legal issue affecting anonymous citizens. It can touch anyone.
And just to put this in perspective, Atlas never actually filed a lawsuit, did they?
No, they didn't. And the liquor board ultimately approved the license transfer for the bar, effectively dismissing the residents' initial complaints about the threatening letter. But
the damage was done.
exactly. The impact on the residents was still significant and devastating. Eben Hansel, Jean Nevin, other residents, despite having valid concerns, they had to immediately hire their own attorneys to respond to the threat. They incurred great expense, time, and anxiety. And this is a crucial point. The mere threat of a SLAPP suit, even without a formal filing, can achieve that desired chilling effect.
Because most people just don't have the resources.
Most people simply don't have those means. They don't have spare thousands of dollars lying around for legal advice, nor the emotional bandwidth to deal with the stress, the disruption to their lives. They would inevitably fold under the pressure, silencing their valid concerns.
And what's particularly baffling, you mentioned this bill has passed the House before.
Yes, consistently. Year after year, it passes the House of Delegates, only to mysteriously die in the Senate in previous legislative sessions. Tom Cole, that attorney and advocate, remains completely baffled by the unseen opposition that keeps stopping it. He noted, whatever is stopping this bill, those conversations are not happening in an open committee hearing.
Interesting. In your experience with legislative processes, what sort of unseen forces typically come into play when a bill with clear public support mysteriously stalls year after year away from public scrutiny like that?
Well, host, that's often the sign of powerful, well-resourced lobbying efforts working behind closed doors. Think about the types of entities who frequently find themselves on the receiving end of public criticism or petitions.
Like big developers, corporations.
Large developers, corporations with significant environmental impact, or even influential local businesses like major restaurant groups, perhaps. They might see a stronger anti-SLAPP law as a direct threat to their business model. They might fear it would embolden citizens to challenge their projects or practices more frequently, leading to potential delays or increased costs.
So they fight it quietly.
Their arguments, often presented in private meetings with legislators, usually revolve around fears of unfettered speech, leading to baseless attacks or hindering economic development. They might argue the proposed law could encourage frivolous claims against businesses or make it harder for them to conduct legitimate operations. It's a classic power dynamic playing out away from public scrutiny, where well-funded interests can exert influence that isn't transparent to the public or even to many elected officials. These are the kinds of conversations that often happen in quiet offices, not in those committee hearings.
Okay, that shed some light. So let's get to the heart of why Maryland's law is considered so weak. That D's grade. What's the core problem?
This brings us to a crucial point about the current law's inadequacy. What distinguishes Maryland from other states with stronger laws? Senator Hedelman highlighted a particularly troublesome provision. It sits at the very heart of the problem. Maryland's anti-SLAPP law uniquely requires the defendant, that's the person being sued for speaking out, remember to prove the suit was brought in bad faith in order to have it thrown out as a SLAPP.
Bad faith. So I, the person being sued, have to prove the other person sued me maliciously.
Precisely. This is a pretty unique provision compared to other states. And as Hedelman explained, it is both difficult and costly to satisfy. It's an almost impossible hurdle to clear, because proving someone else's malicious intent, especially in the early stages of litigation, before discovery really gets going, it often requires extensive discovery and legal maneuvering itself.
Which is exactly what the SLAPP suit is trying to inflict on you anyway.
Exactly. It traps you in a legal quagmire. The law forces the victim of the SLAPP suit to spend significant time, energy, and money proving the other side's malicious intent, rather than simply showing that their public participation was legitimate and protected.
So Maryland's law actually weaponizes the burden of proof itself.
You could definitely say that. It puts an immense, often insurmountable burden on the defendant. Instead of the burden being on the plaintiff to prove their case has merit and isn't designed to silence, the current Maryland law flips it. It forces the defendant to undertake a costly and complex legal fight just to prove they shouldn't have been sued in the first place. It effectively plays right into the hands of those who use SLAPP suits as a bullying tactic, draining resources, inducing fear, regardless of the validity of the original speech.
Okay, that seems like a fundamental flaw. So let's turn to the solutions proposed in the current bill. These reforms, they're designed to directly address these weaknesses, right? To level the playing field.
Yes, exactly. The goal here is to transform Maryland's anti-SLAPP law from, a paper tiger into a real, tangible shield for citizens.
What are the main changes?
The proposed legislation introduces three main reforms. Each one is critical to strengthening the law and bringing Maryland more in line with stronger anti-SLAPP states. First, and perhaps most importantly, the bill would remove that problematic bad faith requirement.
Get rid of it entirely.
Entirely. This is the cornerstone of the reform. It completely eliminates the need for the defendant to prove the plaintiff's malicious intent. Instead, the focus shifts to whether the defendant's speech was on a matter of public interest and thus protected under the First Amendment. It stops trying to delve into the plaintiff's subjective state of mind, which is almost impossible to prove early on anyway. This immediately reduces the burden on the defendant by orders of magnitude. It makes the anti-SLAPP defense far more accessible and affordable.
Okay, that sounds huge. What's the second reform?
The second key reform involves shifting attorney's fees. The bill enables attorney's fees to be shifted away from the defendant, meaning if a SLAPP suit is successfully dismissed by the court, the plaintiff who filed the baseless suit may now be required to pay the defendant's legal costs, often including their attorney's fees.
So there's finally a penalty for filing these.
Exactly. It creates a powerful and much-needed deterrent to a deep-pocketed plaintiff. Makes them think twice, maybe 3 times, before filing a baseless suit. They now know they might not only fail to silence their critic, but could also face significant financial consequences by having to cover the defendant's potentially substantial legal expenses. It introduces a real financial risk for the aggressor, which is currently lacking.
Because right now, there's little disincentive if you have unlimited money.
Precisely. They can just file, knowing the cost alone will likely win the day.
Okay, so removes bad faith, shift fees. What's the third one?
Finally, the measure requires courts to rule promptly on anti-SLAPP motions and to hold off on discovery, except to the extent needed to decide the motion fairly.
Why is that important? Ruling promptly.
It's absolutely crucial, because a common tactic in SLAPP suits isn't just about winning, but about bleeding the defendant dry through the process of litigation itself. Discovery abuse. Imagine having to sift through years of your own emails, provide vast amounts of personal financial data, endure days of relentless questioning under oath depositions, even if none of it is truly relevant to the core claim.
Just burying them in paperwork.
Yeah, that's it. So by requiring swift judicial review and severely limiting discovery in the initial stages, the bill aims to prevent this kind of legal harassment, ensure that frivolous suits are identified and dismissed quickly before they can do maximum financial and emotional damage. It prioritizes efficiency and fairness right at the start, effectively cutting off the oxygen supply to a SLAPP suit.
These 3 reforms sound incredibly powerful together, removing bad faith, shifting fees, speeding up rulings, and it really seems like a comprehensive fix. Is there any potential downside? Any worry it goes too far?
Well, that's a concern that's been raised, but Senator Hedelman, the bill's sponsor, was very clear. She stressed that these changes are absolutely not meant to circumvent the legal process or to chill legitimate lawsuits. The intention is the opposite. They are specifically designed to allow a judge to make early decisions about whether a suit is, in fact, a SLAPP suit, a truly baseless attempt to silence protected speech.
So legitimate cases can still go forward.
Absolutely. She emphasized that this ensures legitimate cases can keep going, allowing valid disputes to proceed through the court system. While the frivolous ones, the intimidation tactics, are stopped quickly and efficiently, it's about creating a clearer filter at the outset, not shutting down justice for valid claims.
Okay. To really understand the stakes here and the profound need for these reforms, let's look at a couple more powerful examples. Cases where Maryland's weak law created significant hardship, even for people who ultimately won. These aren't hypotheticals. They are real people who face immense pressure, financial ruin, emotional distress because of the law's shortcomings. These stories bring the abstract legal terms crashing down to earth.
They really do, and they raise that important question about the sheer cost of fighting these battles, even when justice eventually prevails, and how that bad faith requirement prolonged the agony. Katie O'Malley offered the harrowing story of Mary Ella Jordak, a Kent County woman. Back in 2020, Jordak tagged the U.S. Naval Academy online about what she perceived as a very, very racist comment made by a professor there, Gordana Schiffinelli.
Okay, just tag them online about a comment you saw.
Right. An act of public commentary, directly engaging with an institution about a matter of public concern. For this, Schiffinelli sued Jordak for defamation. Now, Jordak, fortunately, was represented by a team of dedicated pro bono lawyers, meaning they offered their services free of charge, and she eventually won, at trial and then again on appeal. A clear victory, seemingly.
Seems like the system worked eventually.
Well, here's the catch. O'Malley stated that despite her victory, it cost an astonishing $800,000 worth of attorney's fees to defend against the suit.
$800,000.
$800,000. Think about that. This horrifying figure vividly exemplifies the amount of litigation from a powerful entity that can go on without having this law here in Maryland closely more defined, especially when it comes to that bad faith. Imagine being a private citizen, winning your case, being proven entirely right, but facing a nearly $1 million legal bill that, if not for pro bono representation, would have financially devastated you for simply speaking your mind.
Because they had to prove bad faith.
The need to prove bad faith meant endless discovery, countless hours of legal work, appeals all potentially designed to exhaust the defendant. This case alone is a towering testament to how the current law, by extending litigation through that difficult-to-prove requirement, enables financial ruin even for the innocent. It's a win that must have felt like a loss in many ways.
Wow. Okay, and there was another case. A blogger.
Yes, another one that hits incredibly close to home for a citizen simply engaging with their government, a classic scenario. Attorney Tom Cole described how a Howard County blogger he represented pro bono commented on a referendum petition. Remember, that's just a direct civic action to get an issue on the ballot. This seemingly innocuous act resulted in a lawsuit being filed against her the very next day. The next day. And then, in a truly audacious move, Cole himself was sued 2 days later just after he entered his appearance to represent her, essentially targeting her legal representation too.
So they go after the lawyer too.
It highlights the extreme lengths some plaintiffs will go to, not just against the speaker, but against anyone who helps them.
So what was the outcome there?
Well, the bottom line seems to be that despite the plaintiff in this case even acknowledging to the court that the suit had been filed to deter criticism of this referendum petition, a shockingly clear admission of SLAPP intent. The woman's case is still pending after years of litigation, and she's now having to pay for other counsel because the pro bono resources were exhausted.
Oh, wait, even after admitting it was to deter criticism, the case wasn't thrown out?
Nope. Cola stated, "We tried to have it dismissed as a SLAPP suit. The court denied that because the law is vague." He concluded by emphasizing the critical, urgent need for reform, stating plainly, "This law is exactly what we need." These two cases, Jerdak's $800,000 win and the blogger's ongoing fight, despite the admission, they perfectly illustrate the devastating financial and emotional toll exacted by Maryland's current, ineffective anti-SLAPP statute. They are stark warnings.
They really are. Now, naturally, with any significant legal reform that shifts power dynamics like this, there are concerns. And strengthening Maryland's anti-SLAPP law is no exception. During committee hearings, some senators voiced opposition or skepticism, right? Raising questions about potential unintended consequences.
That's right. For example, Senator Mike McKay, who represents Western Maryland, read from a letter submitted by a leader of the group Maryland Right to Life. This letter argued that the bill, if passed, would create a large legal loophole, one that would enable large media outlets and others to willfully malign or defame elected officials, nonprofits, and individuals without legal repercussions.
So the fear is it swings too far the other way, protects defamation.
That's the perspective presented, a fear that the pendulum might swing too far, offering carte blanche for baseless accusations under the guise of protected speech, potentially leaving public figures and organizations vulnerable.
How did Senator Hedelman respond to that?
She countered it directly during her testimony. She emphasized that the bill absolutely does not remove accountability for genuine defamation. She stressed, "You're still involving a judge. The judge has to make an initial ruling to ascertain whether it is indeed a SLAPP lawsuit," meaning the court retains its crucial gatekeeping function. It ensures that only truly abusive and baseless lawsuits designed to chill public participation are dismissed early.
So legitimate defamation claims can still proceed.
Absolutely. She clarified that if someone genuinely believes they have been defamed and can provide evidence, their case will still proceed through the court system. The proposed changes do not serve as a chilling effect to legitimate lawsuits. It's about creating a quicker off-ramp for the truly abusive suits, not a free pass for libel.
Okay. Did McKay have other concerns?
He pressed further, suggesting that passing the bill might reverse the Goliath versus David dynamic, that it might potentially allow individuals to go after a corporation with frivolous lawsuits themselves.
The reverse SLAPP concern.
Sort of. But Katie O'Malley from the Women's Law Center offered a very important clarification. She stated firmly, "This is not doing anything other than leveling a playing field." The core purpose, she reiterated, is to prevent the wealthy and powerful from weaponizing the courts to silence critics, not to empower individuals to file their own baseless countersuits. The reform is about restoring equity and balance, ensuring that speaking truth to power doesn't automatically lead to financial ruin. It's about creating a fair fight, ensuring cost isn't the deciding factor in who gets to speak, not reversing the imbalance, just neutralizing it.
That makes sense, leveling the playing field, not tilting it the other way. What's fascinating here, though, is that even some senators who questioned the bill seem to find some common ground.
Yes, particularly around the shared desire to curb frivolous litigation from all sides. Senator Chris West, for instance, asked specifically about the provision allowing attorney's fees to be awarded if either party plaintiff or defendant acts frivolously during the suit.
So if the defendant plays games too, they could pay.
Exactly. Hedelman confirmed, yes, that was deliberate, emphasizing the intent is to discourage abuse from any direction. And West appeared to approve, remarking, "I'm sure we all agree that deterring frivolous lawsuits is a good thing."
So there's agreement that frivolous suits are bad.
It suggests a broader consensus, yes. No one wants frivolous lawsuits clogging the courts and draining resources. The disagreement lies primarily in how best to define them and, more importantly, how to deter them without chilling legitimate public participation. It's a tricky line, but that exchange shows a pathway to potential bipartisan agreement on the fundamental goal.
Okay, so to sort of synthesize what we've uncovered in this deep dive into Maryland's anti-SLAPP law, it's clear this is a crucial battle. It's about free speech. It's about fairness in our communities. We've seen how this seemingly technical legal thing, that bad faith requirement, has had profound, often devastating human consequences, particularly for the most vulnerable, like victims of intimate partner violence, sexual assault, and just everyday citizens trying to engage with their government, advocate for their neighborhoods.
Absolutely. And those harrowing stories, Mariella Jerdak facing that nearly $1 million legal bill even though she won, the Howard County blogger still fighting a case, despite a clear admission of SLAPP intent. They just underscore how desperately this legal shield is needed to protect those who bravely speak truth to power. And if we connect this to the bigger picture, the story of Maryland's anti-SLAPP law isn't just about legislative mechanics or, abstract legal jargon. It's about the fundamental right to speak truth to power without that fear of financial ruin hanging over your head. The proposed reforms, bolstered by these recent high-profile cases like the Atlas Restaurant Group incident involving Comptroller Lierman's husband, they aim to critically shift the burden away from the defendant, to deter frivolous lawsuits with that powerful threat of shifted attorney's fees, and to ensure prompt court rulings. This, in essence, will help ensure that our legal system remains a venue for justice, a true arbiter of disputes, and not just a tool for intimidation. It's about allowing public participation and free expression to flourish rather than wither under the constant looming threat of litigation.
So what stands out to you about this deep dive? As these legislative efforts continue in Maryland, And as the fight for stronger anti-SLAPP protections continues across the country, maybe consider, how effectively do the laws in your state protect public participation? And what might be the true, intangible cost to civic engagement, to community vitality, to individual freedom of not having a truly strong shield against SLAPP suits in your own community? Think about the voices that might never be heard, the questions never asked, the truth that might remain unspoken, all out of fear.